Good morning, everybody. Glad you could join us this morning for MetroIBA's Education Committee webinar series. I'd appreciate it if somebody could please text chat in the bottom left corner if you're hearing us okay. I've listed the numbers on the text chat. Also, if you have any audio issues, you can try the phone bridge, and that's 1-312-702-1380, and the PIN number 54894#. Thank you, Wendy, for texting in. I'm glad you can hear us all okay. So tomorrow, if you do have any questions throughout, feel free to text chat those in, and Jen will take them as we go. We can also have some time for Q&A at the end of the presentation. Just so everyone knows, the webinar is being recorded. I'll provide those links later on today. They'll also be available from our website. So if you don't have to worry about taking notes right now, or just you can focus in on what Jen is presenting, and we'll get those so you can review them later. So this morning we're very excited to welcome Jen Jambor-Delgado, a founding partner of Jambor Heyman, which is a very unique law firm in the city. It specializes in both natural, organic, and specialty food production, marketing, and distribution. Jen has been practicing law for over 15 years. 9 of those have been spent in the advising food, beverage, and farm business. 6 have been spent as an employment and labor law attorney. So we're really excited to have Jen today talk about protecting our brands, Trademarks 101. Again, if you have questions, feel free to text chat those in, and we'll begin shortly. Thanks. Here's Jen.
Thanks, Jill. Hi, everybody. Thanks for joining us today. I'm Jen Jambor-Delgado with the Jambor Heyman Law Firm. And as Jill mentioned, we specialize in working with food businesses, pretty much from soup to nuts. So from when you form a business entity, we handle contract work, labor and employment, leases, purchase agreements. If people are taking on investors or selling their businesses, we will help them with that as well. And our firm we started 3.5 years ago. We are a 2-person law firm and have worked with many food businesses and also sort of businesses that operate within the green space here in the Twin Cities and also across the country on federal law issues, including trademark. And today I should advance the slides here. So we will be talking first today about what a trademark is, covering some basics, exploring the subject of why someone might trademark, the basics of the federal trademark registration process, the benefits of registering a trademark, and then walk through the trademark process itself, trademark searches, applications, the issues that can come up during the application process, and then what you need to do if you have a registered trademark in order to protect that. And my hope is that you will walk away from today's webinar with a good sense of how the trademark process works, whether it might be worthwhile for you to invest in getting a trademark, and how to use trademarks to protect your brand. So moving on to the first part of the presentation, what is a trademark? We've got listed here the various items that a business might want to consider trademarking. And I've listed these pretty much in descending order of importance. So typically you would think about trademarking either your company name or your brand or product name, your logo, your tagline, and then less frequently either graphics, color, shape of packaging if you have sort of an unusual type of product shape or packaging. So for example, like the Coca-Cola bottle was trademarked, and you may have like a special box or a packing crate that you wish to trademark. But generally speaking, that's less usual than doing your brand name, your logo, your tagline. And the idea is that these are either words or visual items that you use to identify your goods or services and distinguish them from others. And that is sort of the basic explanation of what a trademark is. A trademark is not domain name registration or reserving your business name with the Secretary of State. It is also not generic terms that describe a product or services. So, for example, one of our clients is Cold Front. It's an ice cream store, and they've trademarked Cold Front. But if they had sought to just trademark ice cream shop, they would not have been able to, because that's a generic term describing what they do. Or, for example, hotels.com for a website providing hotel reservation services. That would be considered generic as well. So the reason we have go through what a trademark isn't is because there are times where newer businesses are under the impression that they have some sort of trademark rights when they have reserved a name with the Secretary of State or have registered a domain name. And so that does not give you trademark rights at all. You may have some reservation of rights if you've gone through those processes, but it's not the same as having a trademark right. And trademark law generally protects marks which are distinctive or out of the ordinary. Like I said just a minute ago, they don't protect generic terms or words that are just descriptive of the goods or services you're providing. So I've included here some examples of distinctive or otherwise unusual marks. So, for example, unique logos like the Nike swoosh, or made-up words like Kodak for film or cameras. Arbitrary marks, which are words that are somehow surprising or unexpected. They really have nothing to do with the goods or services being provided. And Apple for computers is an example of that. And then there are also suggestive marks, which are words that describe the qualities of the product or service and allude to them, but don't simply describe them, like contact for self-adhesive shelf paper. So that, in a nutshell, is what a trademark is. And I've included on the next slide some examples of clients we've worked with and terms we've trademarked on their behalf. So Filia Foods for cheese spreads, Gustola Granola for cereal bars and granola, Cold Front, which I mentioned earlier, Brookside Beer Battered for providing food and drink through a mobile truck, and Growing Green Hearts for educational services. And you'll see there that none of these words or phrases simply describe a product or service. So, for example, with Brookside, had they sought to register fried fish food truck, they would not have been able to get a trademark. But they have a name that has nothing really to do with what they're doing. And that's what makes it unique and worthy of getting a trademark. So Trademark Basics. You can have trademark rights without registering for a federal trademark. These are referred to as common law rights, and they arise from your use of the mark. But you are only protected within the area, the geographic area where you've actually used the mark. So if you have a brand name and you are using that name in connection with certain goods or services within the state of Minnesota, let's say, you would have common law trademark rights within the state of Minnesota. But if a competitor went and used a very similar name on very similar goods or services in a neighboring state, you would not have superior rights over that person. They could use their mark wherever they were, and you could keep using your mark in Minnesota. But consumers might get confused and think you're the same business. And so, although you do have common law rights that are based on your use of the mark in the geographic area where you're using it, those rights don't protect you against a competitor who's using the same or similar mark on the same or similar products in a neighboring state or somewhere else in the country. So let's see, anything else I want to say on this? You can do a registration of a mark within Minnesota. Again, your protection's only within Minnesota. So it's the same geographic area of protection that you would have through your common law rights, The only reason, well, I shouldn't say the only reason, but the primary reason you would register within Minnesota is to put others on notice that you are using the mark. So it's basically a deterrent to other businesses that are determining what their brand name or company name will be, and they're looking to see what's out there and doing some searches. And you're more likely to turn up in those searches if you have registered your mark within the state of Minnesota. So even if you don't qualify for a federal registration, it might be useful to do a registration within the state of Minnesota, even though you don't actually get wider geographic protection from doing that than you would have through your common law rights. It's really just to put others on notice. So moving on, federal registration requires actual use in interstate commerce. And just a minute ago, I mentioned that you might not qualify to get a federal registration, but that you could still register in Minnesota. And one of the reasons that you might not qualify for a federal registration is because you don't have use in interstate commerce. And I will talk a little bit later about what that actually means. There are some specific interpretations around use in commerce. But the point I want to make through this slide is that you can register if you have actual use in interstate commerce, or you can do what's called an intent to use application based on your bona fide intent to use the mark in interstate commerce. And that basically allows you to sort of plant your flag and put the Patent and Trademark Office, which is where you register a trademark federally, on notice, and anybody else who's applying for a trademark at the federal level, that you intend to use that mark in connection with certain goods and services. So even if you don't have actual use in interstate commerce, you can still file a federal trademark registration if you have an intent to use that mark in interstate commerce. And what federal registration provides that state registration does not provide and common law rights do not provide is you have nationwide protection. So back to our earlier example, if a competitor is using a similar mark on similar products in another state and you have a federally registered trademark, you have protection against that competitor's use of that mark. And you can take steps to limit their use of the mark or stop their use of the mark. And I'll talk more later about what some of those steps might be. So that's your big benefit of federal registration, is you've got nationwide protection. And again, you also have that deterrent effect, because when people are starting the registration process, what they should be doing is starting with a search, where you look to see if there are other marks that are already registered or have been applied for. And you will pop up in those searches if you have a federal application filed. And so that lets people know, hey, oh, okay, there's already a similar mark out there on similar products. Maybe we should be looking at some other names. And the other thing it does for you is, because you've already filed your application, you are first in line at the Patent and Trademark Office in connection with that mark. So if someone else comes along and files an application after you for a similar mark with similar products, their application will not be successful. Or it shouldn't be, I should say. The Patent and Trademark Office will likely refuse to register that mark based on the fact that there is a previously filed application, yours, for a similar mark in connection with similar goods or services. So the symbols that you use when you have a trademark, we've got listed here. So if you don't have a federal trademark, but you want to tell people who might see advertisements for your services, or maybe on your product label, that you are using certain words as a trademark, you can use either the TM symbol or the SM, depending on if you are using the symbol in connection with goods or services. And that's another way of putting people on notice that you are using terms as a trademark and not just, using the words in their sort of common usage. And then once you have a federal trademark, you can use the federal registration symbol, which is the R in the circle. All right, so why trademark? I think I've alluded to this, but one reason is because it gives you the right to exclude others from using the same mark or similar mark with the same or similar goods or services, which helps you to protect your brand. And the primary purpose of trademark law is to prevent unfair competition. And when the owner of a mark or a brand has spent time and money presenting that business's service or products to consumers, and somebody else comes in and sort of taps into the goodwill that the business who owns the mark has built over time, they are unfairly taking advantage, essentially, of the work that you've done to protect your brand and business. And so trademark law provides a means of preventing that or providing a remedy when that happens. And the idea basically is that if a business has built a trademark, they've invested in it, they should be able to protect that asset and continue to build on it and grow on it, and others should not be able to unfairly collect and get a return from someone else's work and investment in that arena. And there's also a rationale of consumers should be able to know which business they're dealing with, and it can be confusing to consumers if multiple businesses are using the same or similar marks on the same or similar products. So one main reason to trademark, of course, is to protect your investment in the value of your brand name. And as all of you have likely experienced in your own businesses, marketing and relationships are really so key in the many small business sectors. And when you invest in trademarking your brand, you're protecting the good name of your business, and you're protecting sort of the entire brand identity that you have built around that business and that buyers associate with your products or your services. Also, your brand is a business asset with monetary value, and locking down your intellectual property rights through a trademark helps to protect that business asset and the monetary value associated with it. Certainty, owning your intellectual property is always a good thing. If you are looking down the road at sort of what your exit strategy is for your business, and you think you might want to possibly take on investors or sell your business, one thing that investors and business buyers are likely to ask about is whether you own your intellectual property or not, because that is going to affect their willingness to invest and the price they're willing to pay for the business. Because if you don't have the certainty of owning your brand name through a trademark, that makes it a less valuable asset. And so people are less willing to invest and or buy your business. Also, owning your trademark helps to avoid bad surprises down the line. You know, investing a lot in your brand initially and then in growing that brand, and having somebody come to you with a cease and desist letter after your business is up and running is a really, really unpleasant situation to be in. And rebranding is costly and time-consuming, and defending against a cease and desist or an infringement suit is very time-consuming and very costly. So knowing that you have rights to your brand through a trademark is really helpful in providing that certainty. Registration also helps you to avoid issues. So one thing we look at, and I'll talk more about this in a little bit, is if we're doing searches for a client, we not only look for sort of the practical hurdles that the client will have to deal with in trying to register their trademark on the Patent and Trademark Office front, but we also look to see if there are other players out there who have very active trademark enforcement programs that could cause a problem for our client. Even if legally any claims that this business would bring against our client might not end up winning, it's still something you want to head off. So with us, we work with a lot of food brands. So if we're doing, let's say we had a list of some of our clients and their trademarks earlier in the presentation. One was Filia Foods, they have a cheese spread. So if we're searching for a cheese spread and we see that there's a big food company that has a name that isn't exactly like Filia but has some similar sounds or could somehow be associated with that word. Let's even say it's like, let me think, instead of Filia Foods, we've got like Filia Wine and Spirits, and this is a big company that has deep pockets. We're going to think about that when we're advising our clients about what steps to take, because if you know someone's got an active trademark enforcement program and that they've gone after smaller businesses before and they have the economic means to pursue those cases, it's just a practical problem that can often be headed off or avoided if you do a thorough search and you see that sort of possible obstacle out there. You can think of ways to avoid or minimize the risks associated with that. And we also have, as our final point under trademark bullying here, economic inability to defend. And what that essentially means is small business owners who receive cease and desist letters are often in a really helpless position, because if they do get sued, it's very expensive. And so finding these issues on the front end instead of having to respond to them defensively is a much better position for small businesses to be in than having to defend in an infringement action or, hire an attorney to look at the cease and desist letter, analyze the merits of it, and help you figure out a strategy and how to move forward with that. So moving on to why trademarks some more. So this is sort of a general rule of thumb. So selling products or advertising services across state lines, expanding regionally and nationally, or if you're planning to take on investors or sell your business eventually, or you want to have the option of doing so. If you fall into any of those categories, it's definitely worthwhile to think about getting a federal trademark. And if you don't fall into any of them, but you think, okay, I might be, right now I'm only selling here in the state of Minnesota, and maybe it doesn't make sense for me to trademark, but I am thinking about expanding and hoping to be selling like in the upper Midwest within the next 2 years. That's the kind of situation where you want to think about filing an intent to use application. And then you can reserve the name, reserve your place in line. Anyone who comes along behind you and files an application for a similar mark in connection with similar services will have junior rights to you in terms of the trademark application process, and their application will be suspended until your application is either approved when you finally register or denied if you end up getting denied. So this is sort of our general rule of thumb for when you should seriously think about investing in a trademark. And then moving on to what that process looks like. So the Patent and Trademark Office is the federal agency in charge of trademarks. You apply to their office for a federal trademark registration. Everything can be done online. There are a staff of, and I'm sorry, we have a typo in this slide that says patent examiners. That should be examining attorneys. The examining attorneys make decisions about all trademark applications, and essentially what they do is they compare your proposed trademark to the rules for what can be trademarked, and I'll talk about those shortly. And then they also compare your application to any existing trademarks or trademark applications. And if they find an existing trademark or trademark application that's very similar to yours, then your application is very likely to be denied. And we can talk more about what that looks like in a minute. Then the examining attorney may ask for more information. They may ask for changes. And if they don't see any issues, they will push your application forward in the process. And the process is essentially sort of a hurry up and wait type of process. So it's very important to get your application filed as soon as you can, because again, if you're first in line, you're going to have better rights than anyone who files an application after you for a similar mark. But once you've filed your application, and we have a detailed timeline in a few slides where I can go through this more, but once you file, you wait about 3 or 4 months currently for an examining attorney to be assigned to your application. So it is as I said, very much a hurry up and wait process. So you go through the, process of getting all of your information together, figuring out your trademark strategy, getting that into the application and filing, and then you just wait. All right. Federal registration benefits. I talked earlier about sort of the nationwide rights to your mark. Also with federal registration, your mark's validity is presumed, and as is your ownership to that mark and your right to use it. And then after 5 years of having a registered mark, your mark attains an incontestability status, which makes it much harder for anyone to attack in court. Without federal registration, as we discussed earlier, you only have rights to use you only have trademark rights in the geographic area where the mark is being used. And so you can't block a competitor in another state from using the same or a similar mark. If you are thinking about registering a trademark, the first step is to do a search. You can do some preliminary self-searching either on the Patent and Trademark Office database, the Minnesota Secretary of State, Google. I also recommend checking Facebook and Twitter, other social media platforms, to see if there's anything out there that is similar to the name you are thinking of adopting for your business or your product. Let's see. So those are self-search options that you can do. I would not rely on those as the basis for moving forward with the trademark application process. I consider this a very preliminary step to just get a feeling for the lay of the land. And then there are also knockout searches, which we sometimes do for our clients when they are coming up with a new name for their business or a new product. I think a good rule of thumb in that case is if they can give us 3 names, we will do knockout searches for those. And those are really designed to find obvious problems, like an exact match, for example. And for those, we will do the same sort of searches that I described above. And that is also an area where we sometimes work with people who do marketing or brand development, and they will come to us when they're working with a business and give us the names that the name or names that the business is thinking of adopting for itself or for the product. And they're working with this marketing or brand development person or company to come up with their strategy around that and what it's going to look like and what the brand identity will be. And we will help by just checking quickly for obvious obstacles, because it's really unfortunate when a new business invests a bunch of time working on a brand identity and then they go to trademark it. After everything's done, they've picked their name, they've developed their logo, they've got all sorts of great marketing materials that have the name and logo incorporated, and then you get to the federal registration process and hire someone to do a search for you, and you find out, oh, wait, somebody else doing the same thing already has that name, and we're going to be in hot water if we adopt it too. So we do searches a lot for our clients. As I said, we sometimes start with a knockout search. Other times we just jump in and do a full search where we're looking for obvious obstacles, and then assuming we find none, we go beyond that and look for other possible issues that could come up in the course of the trademark application process. And then we will work with our client to help them minimize those risks. And basically what we do is we analyze all of the search results and we develop a recommendation for the client about what their trademark strategy should be. And, it's interesting because the trademark application itself does not call for a ton of information, but there are decisions that go into what information you put in that application that are very strategic. And this is something where it is worth working with an attorney on it, because you really can minimize your chance of running into problems by having that process be part of your trademark registration process, sitting down, talking with an attorney, analyzing risks, and then strategically making decisions about how to best develop a trademark strategy for you and the way to implement that trademark strategy for you. People can also commission professional searches. Those can be pretty costly. Some of our clients do it, some don't. I would say, around $450 to $500 for the professional search. But then you still need an attorney to analyze those search results. The professional searches are great in the sense that they really are very comprehensive. You get a big binder or an online binder, if you wish, with hopefully not too many results, because that means there's a lot out there and you're stepping into a pretty crowded field. But if it is a lot of results, that's what it is, and you're better off knowing it. And then what we do in that case is we'll go through, analyze the search results, and again, come up with a recommended trademark strategy for our client. And then reserving brand names, this is the intent to use trademark application that we talked about earlier. And I think we covered that well enough. Let me see if I have anything else on this. I think that is it on that slide. If you already have a name, which is very common, we work with a lot of businesses that when they're starting up are not in a place to invest in a trademark. And they're just trying to figure out if their business is going to have any legs, and they have limited resources, and so they're not going to put them into a trademark right away. And then a couple of years down the road, they decide, okay, well, this business really does have some potential and I'm going to keep doing it. And then they start making some of these decisions about what they need to do to protect their brand. In that case, if you already have a name, again, it's the same process really, that you go through the search, the analysis, you find potential issues, and then you make strategic decisions about an application. The knockout searches I mentioned earlier don't really apply or help too much in this arena because you already have a name, so it's not like we're looking at 3 potential options and figuring out which ones have obvious obstacles and which ones have a better chance of succeeding on the trademark front. And let's see, so I think we've talked about everything on the search front. General application information, the filing fee for an application is between $225 to $325 per mark, and that's in one class. Generally speaking, the $225 fee has worked for our clients. It's a more streamlined application form, and we've used that, I think, for almost all of our clients. And when I talk about class, the way the trademark system works is there are different classes of goods and services. And so when you're filing an application, you have to figure out which class is the right class for your product or your services. And sometimes your product or services might fit into multiple classes. So something that comes up with our clients a lot is some of them may be providing restaurant services, but they also have actual food products that they're selling as well as sort of like an adjunct to their restaurant. So let's say they have like a line of sauces or salsas or something like that that the restaurant also sells. So the sauces would be in one class, restaurant services are in a different class. So in that case, our client would have to pay $450 because they're registering in 2 classes. So that's your filing fee. If you're filing an application based on actual use in commerce, you also have to have a specimen that shows your use of the mark in commerce. And so for goods, that can be a product label or a website with a website screenshot that shows like the shopping cart on the website, because it shows that people can actually make purchases. Most of our clients were able, because we work with food businesses, they have their product label affixed to their product, and that is generally what we will use for a specimen. Sometimes for restaurants, the signage outside of the store will also work. And then if you are a service-based business, like you're doing accounting services or marketing services or something like that, your website or screenshots of your website or your marketing materials are acceptable specimens generally. So there are strict requirements. Once your application has been filed, it will be scrutinized to make sure it complies with all of the requirements, and if it doesn't, you might be denied, but also what often happens is the examining attorney will get in touch with the representative for the application, which when we're working with the client is us, and let us know, here's what the problem is, and ask us for permission to make a change. So sometimes what it is they'll want a disclaimer in the application. So a disclaimer basically states that you're not trying to claim rights in a word that's part of the mark outside of that word's context as part of your mark. So one of our clients has the word granola in their mark, and they have to disclaim granola because they're not trying to trademark the name granola on its own, right? They're trying to trademark granola in the context of their brand name. So those sorts of things can be handled quite easily, usually through phone or email with the examining attorney. And then there might be more serious issues that require a written response. On average, when you file a trademark application, you are looking at about a 1-year wait with no problems. So that means like there are no serious problems, nobody opposes your application, nothing like that. I think generally we're seeing like about a year, maybe a little more for those applications from start to finish or filing to finish. Okay, so here are some reasons a trademark application might be refused. And these are the more serious situations that I referred to on the last slide. So there are times when the examining attorney will just seek clarification, like a disclaimer or ask you to amend your description of goods and services or something like that. Those things can be handled pretty easily and informally, as I said, through phone or email. It's also possible that the examining attorney will issue an initial refusal of the application, and then you have the opportunity to respond in writing to that refusal, and you have a 6-month period of time to do that. One basis for refusal is likelihood of confusion, and that's sort of the frontline thing we're looking for when we're doing trademark searches, is are there other similar marks that are out there that are used in connection with related goods and services. We're also thinking about whether or not those goods are sold in the same channel, so whether the consumer or customer is encountering those things sort of at the same place. And for our clients that are food businesses, the answer is almost always yes on that last point because their items are typically at the grocery store. Another thing that can come up is complementary goods or services. So sometimes you might do a search and see that there's another mark that's similar to yours, but it's used on a different type of service. So let's say you do accounting and there's a similar mark that's used in connection with home insurance services, right? And you think, oh, well, that's home insurance, I'm accounting, no problem. It is possible that the trademark office would disagree with that point of view and find that those services are related enough that there is a likelihood of confusion issue. And the baseline is essentially, would a consumer be confused and think that these goods or services are coming from the same source? And so that is sort of like the big thing that we're always looking for when we're doing searches, and that the examining attorney is looking for when he or she gets an application. Other issues that could arise are your application could be refused on the basis that it's merely descriptive in that it just describes the quality of the goods or services you're providing, or it could be refused because it's deceptively misdescriptive and it misdescribes the quality of the goods or services you're providing, and that misrepresentation is plausible and something that a consumer would likely rely on. There's also a category of refusals that fall into sort of this geographic category. And the first is that it's primarily geographically descriptive. So the primary significance of the mark is geographic, and buyers think that the goods originate in that place. And the mark accurately describes the place that the goods originate. So an example of that would be like Napa wine. Right, Napa is very well known for wine production, and a mark that said Napa wine really does just geographically describe, assuming the wine is actually produced in Napa, a product that is associated with that place. Now, if you had a wine product that was labeled Napa wine that was grown in, I don't know, Dakota County in Minnesota, you would fall into the primarily geographically deceptively misdescriptive category of refusal. So if you have a mark that incorporates a place name, you need to be thinking about whether you might run into a refusal for either of these reasons. And then that is the sort of thing where we are going to be making strategic decisions with our client around those things. So if they have a place name incorporated, we need to think about how that plays into their trademark application and deal with that on the front end. Other reasons that may arise for refusing the trademark application are if the mark is merely a surname, if it's ornamentation, just a decorative feature of the goods. So for example, if your product label say locally made and you tried to trademark locally made, that's not something that uniquely identifies your product. It just is a feature of your goods that you have described on your product label. And then disparaging marks. So a common example for that is Redskins. Cannot be trademarked. So moving on to the trademark application timeline. So we start out with a knockout search, if that makes sense, and that can be done very quickly. Professional searches can take longer, but you can also rush them if you need to. Then we do our analysis, and if a client wants us to, we'll draft a written clearance opinion. That is a good thing to do when you're investing heavily in a brand and you are forecasting potential issues. Because it helps provide a good faith defense in any sort of trademark infringement lawsuit or in case of any allegations of trademark infringement. Often our clients are not in the position where they want or need to invest in a clearance opinion. Some are, but many are not. And in that case, we will either provide just an oral recommendation to the client and describe to them what we found in the trademark search, what our analysis is, what our recommendation is, and then discuss next steps with them. And that can all be done orally if that's what the client wants. Also, we can also just provide them like little bullet points instead of a full clearance opinion. So sometimes people want something in writing, but they don't want a big memo because that takes more attorney time and costs the business more. So we're flexible on those things because we work with a lot of small businesses and we're very cognizant of the fact that they're living in with resource restraints. Trademark application completion can be done fairly quickly once we've conferred with the client, gotten all the information we need to complete the application. And then as I mentioned earlier, once that's filed, you just wait. So 3 to 4 months, then you get your examiner. You might get a minor office action, like the disclaimer request I mentioned earlier, or a request for some sort of information, or to edit the description. Those can all be handled very quickly. If your application is refused, you have 6 months to respond in writing and explain why the application shouldn't be refused and why the basis for the refusal is not good, basically. Your application can also be suspended. So if there is a prior filed application that is for a similar mark or the same mark in connection with similar goods or services, your application can be put on hold essentially until the previously filed application is decided. And then if that application is granted, yours will be refused based on likelihood of confusion. If the previously filed application is not granted and it's refused for any reason, then your suspension will probably be lifted and your application can move forward. After that, there's a notice of publication where your application is published in the Trademark Office's official gazette. That is a 30-day publication period. During that time, anybody who wants to oppose your application can file an opposition to it, or they can seek an extension of time to file an opposition. In the most cases, anybody who wants to oppose your application will first file for an extension of time, and that gives the parties a period during which they can try to resolve the dispute before an opposition has to be filed. If an opposition is filed, then your application is indefinitely delayed, and you either settle the matter with the other side or you go through the opposition process, which is similar to like a mini trial, but mostly on paper. And then if you make it through the publication period with no extension of time to oppose filed or no opposition filed, you typically move right on forward and your trademark registration is issued and you get a nice certificate in the mail. And then you have to start monitoring your mark. All right, so moving through that, here are some of the issues that can come up on the government side. I think we've hit on many of them. An office action, a suspension, or a refusal. So with minor office actions, you just clear the issue up with the examining attorney. In the case of a suspension or refusal, basically what we would do is analyze the merits of the basis for the suspension or refusal and help the client figure out whether or not it's worthwhile to invest in responding. Private party issues that may arise during the application, extension of time or opposition, which we just talked about. At any time, whether you are going through the trademark process or not, you could receive a cease and desist letter or a trademark infringement lawsuit. If that happens, if you get a cease and desist letter ever, they are written in a way that is meant to be very intimidating. And it is worthwhile to have somebody take a look at the cease and desist letter for you, do some research into the claims of the party who sent you the cease and desist, and help you figure out how to respond to it. It's a scary thing to have happen, and it's a really big pain. But it can be handled, and it is worthwhile to work with an attorney on it, and definitely not ignore it, because that is a pretty natural inclination sometimes, but it doesn't help. And so your options for resolving trademark issues with a private party generally fall into three categories. One is you defend against the lawsuit, or you figure out some sort of litigation strategy to respond to the cease and desist letter. Another is you work out a specific type of settlement called a coexistence agreement. And basically what that is each party agrees to kind of stake out their terrain. Like they are using the mark in connection with certain goods and services in a certain geographic location, and you are using the mark in connection with other certain goods and services in another geographic location. And you're basically saying, we're using these marks in different ways and or different places, and we don't believe there's any likelihood of confusion issue. So that is a very common type of settlement in trademark disputes. The other is licensing, where the senior holder of the trademark rights can grant your business the right to use the mark, and then you pay them money in exchange. After you have registered a trademark, you do have to make periodic filings, basically attesting to the trademark office that you are still using the mark in commerce. If you fail to make those filings, your mark will be deemed abandoned, and it is basically up for grabs. So these are really important to do. So during the time period between the 5th and 6th year, you need to make a filing, and then between year 9 and 10, and then you have to basically renew your trademark every 10 years. So those are things you need to have on your radar. Another thing after registration you need to be aware of is you need to monitor your mark now, because, right, you own it, but if other people are freely using your mark in ways that are infringing or confusing to consumers, you may be giving up some rights in your mark. So different means of monitoring your mark are you can do Google Alerts. TalkWalker is a free service you can use to register or monitor your mark. And then there are also many different paid services out there that will monitor and provide you with periodic reports. We talked earlier about using the trademark registration symbol. Once your mark is registered, you do need to incorporate that into your product labels, your marketing materials, other places where you advertise. And you can do that through use of the R in a circle or through these other phrases that we have listed here on the slide. So bottom line is trademark is an effective way of protecting your brand investment and also preserving your exit options. And understand that it's a hurry up and wait situation and that it does not happen quickly. So you're looking at least from filing your application to getting your registration at about a year. Pushback can happen both on the governmental front and from other private parties. Once you have a trademark, it doesn't just sit out there and exist forever. You do have to do things to keep it up, including monitoring and doing the required filings. And if you do find people using your trademark in ways that infringe on your use, you can use the license option that we discussed earlier as a way to protect your trademark rights. So that, I think, is it on our end. And if any of you have questions or think of things later that you'd like to run past me, you should feel free to reach out by email. I'm happy to answer any questions people have, provide additional resources if needed. And I think Jill might be renewing your trademark. I just got a question, sorry. Renewing your trademark, are you alerted or do you need to remember? Both is the answer. So you should calendar it. When you get your trademark registration, you will get a letter along with it that tells you the dates during which you have to do these upcoming filings. And I would recommend calendaring that and then also having like pop-ups that are going to remind you in advance of the date. You should get additional sort of notices in the mail that remind you, but I would not rely on that because people move around, and so I think you get your initial dates, calendar it, and just have it in mind that that is something you need to remember on your own. Also, if you're monitoring your trademark, that will be on your radar too because you'll be checking the Patent and Trademark Office database and having someone do that for you. A second question just came in that asks, is there an estimate or average on cost for this process to trademark? I would say it's very different depending on how many complicating issues you run into. So if you are, like I said earlier, the filing fee is typically $225. If you're filing in more than one class, it's going to be $225 per class. So you have to factor that in. For us, for attorney time, if we are doing sort of like the full thing for somebody, including the search, the analysis, development of a trademark strategy, and a recommendation for the client, filing the application on the client's behalf, and then monitoring development, I would say generally speaking, we are able to keep our fees to $1,000 or less. That can vary, like for example, if you end up with an initial refusal, which we would hope would not happen, but if you do and we have to do some written follow-up to the PTO on your behalf, that would increase the cost at that point. But generally, that's the ballpark that we end up being in at our firm is $1,000 or less. And I feel like I had something else to say about that. Oh yeah, we typically will do cost estimates for our client too. And I encourage any of you when you're working with an attorney, whether it's our firm or a different firm, to ask for that. And in something like trademark, people should be able to give you a cost estimate. So, and then the way we handle that is we'll give clients a cost estimate, and if an unexpected issue comes up that makes the application process trickier than we thought it would be for some reason, let's say a new case gets issued right before we file your application that might affect your application, we would go to the client and seek authorization to do the additional work and let you know how much we think it's going to cost before we actually start doing that work. So that's the way we do it. Other attorneys are different, but definitely attorneys should be able to give you a cost estimate before doing a trademark for you. Do we have any other questions, Jill?
Not right now.
All right. Should we wait a minute and see if any come in? Or?
Sure.
Okay. So we are just going to take a minute here, see if any other questions come in, and if they don't, we'll just close this out.
Okay. While we're waiting. Thanks so much, Jen. That was very informative and really helpful to understand this process. Jen's information is listed here. The best way to reach her would be through the email at jen@jamborheyman.com. We'll provide those contact information as well when I send out the link for the recording too. And one thing, we can give you some upcoming events for MetroIBA. We're really glad you attended the webinar today. If you have ideas for different webinars you would like to hear, we'd love to hear that too. So you could email us at info@metroiba.org and give us your ideas about what more you would like the Education Committee to provide. We hope to see you at some of our upcoming events. The first Tuesday of every month, we have our First Tuesday networking event. This one's coming up September 6th from 4:30 to 6:30 at the Birchwood Cafe. It's a great opportunity to have some light refreshments and chat, network, get to know the different members of MetroIBA. We have a couple of more B, which is our MetroIBA Owners Roundtables for Excellence in Business, and these are member-only roundtables, but they provide a wonderful, almost a support group, a real problem-solving, hands-on opportunity to work with your peers to problem solve, throw out ideas. It's a great idea. It's a really good service. We're having some great success on that. So we have two different groups that meet. One are on the third Tuesdays of the month, and that's the afternoon one from 3:30 to 5 at Chess. The other is a morning group that meets on the fourth Thursdays from 7:30 to 9 in the morning, and that's over at the Wild Cafe, previously known as the Wild Rose Cafe. We also would ask members to save the date. We have our Public Policy Caucus coming up on September 27th, and this is actually from 5 until 8:30. It's a little bit longer than what I have listed there at Hamilton Johnson, a beautiful location. And we're hoping to see a good turnout from members. You can register for that online. The contact information is on our website as well. First Tuesdays, there's no registration needed. Anyone is welcome. And you can see more if you visit our BuyLocalTwinCities.com events for more information. And MetroIBA's Education Committee provides these webinars for both members and non-members alike. We're happy to help anyone grow in their business or learn more about us. If you aren't already a member, though, and you're interested, feel free to go to BuyLocalTwinCities.com, join, and learn more about the benefits of being a member and what we can do for you. We're not seeing any more questions. So with that, I really want to thank you all for your time this morning, and thank Jen. She did a marvelous job. As she said, if you have questions that come in later, feel free to email her later, and look for the recording link and contact information to come out later this afternoon. Thank you so much, everybody. Bye.